Okay, welcome back, everybody. This is part 2 of the all-day law class, Vocational Science of Freedom, and we are covering the doc set for the Vocational Science of Freedom, and we are coming back to where we left off, which was where we were talking about the understanding of the law merchant. Handouts can be found in the Dropbox from Mega, which there'll be a link in the description notes, and you can also find the description notes in the Vocational Science of Freedom Gilded server, which you can also join by clicking in the upper right-hand corner of the Vocational Science of Freedom YouTube page where it says Join Gilded. It'll be right in the banner in the upper right-hand corner of the screen. So where we left out was we're talking about the law merchant and what it is. And so this is a modern, I think that it was dated, 2006. So this is a fairly modern document, a law essay on the law merchant. Now, of course, it's 128 pages. I'm obviously not going to go through all this, but I just want to make sure to give it to everybody so you can get a good understanding as to how the law merchant still affects us and how they're using Roman civil law to control every aspect of what we do, even if we're not being a merchant or we're not subject to that law. So to begin here, modern advocates of corporate self-regulation have drawn unlikely inspiration from the Middle Ages. On the traditional view of history, medieval merchants who wandered from fair to fair, again, that's talking about the fair courts, were not governed by domestic laws, but by their own lex mercantoria, or law merchant. This, and a little bit of historical understanding of this, about that they weren't subject to domestic laws. This is the aspect of where you get into English history about when Roman the Conqueror came over in 1066, and the Jews were considered actual property of the king, but they were not subject to the laws of the people. This is where they literally had their own law, okay? And the king allowed this. So in a weird way, they became a favored race, if you will, where the king literally saw them as his property. And then, of course, that all ended with Edward the Longshanks, the Hammer of the Scots, who was the man portrayed in Braveheart, the movie Braveheart. What he did was he came along and he said, okay, enough of this shit and enough of you. And he laid down the Edict of Expulsion, which is still in full force and effect today. Oliver Cromwell, who was a Khazarian mob agent, tried to overturn it during the Civil War of England, but he had no power to do so because he wasn't a king. So he had no ability to overturn a royal decree. So the Edict of Expulsion basically said that all the Jews had to leave England under pain of death. And if they didn't leave, then all of their property was considered to be confiscated. And that edict is still in full force effect. You can look at the Edict of Expulsion, something you can easily find and research as to what Edward did. And so they had their own law. They were not subject to the common law. There was two different forms of law, and they were the ones that had this, the law mercantoria or lex mercantoria. So to continue, this law, which uniformly regulated commerce across Europe, was supposedly produced by an autonomous merchant class. Again, the Khazarian mob. Interpreted in private courts, their own courts, and enforced through private sanctions rather than state coercion. Contemporary writers have treated global corporations as descendants of these inerrant traders, urging them to replace conflicting national laws with a transitional law of their own creation. They always want to have their own law, they always want to have their own rules, and they don't want to be subject to anybody else's rules. Surprise, surprise. This is their modus operandi, which they've done for thousands of years. The standard history has been accepted by legal scholars across the ideological spectrum, by economists and political scientists, and by those drafting new regimes to govern internet commerce. See? So all of the attorneys are well aware of what's going on. They cloak it in this type of language instead of telling you what is actually going on, which is what I'll tell you, and telling you the true history of all this. So to continue, this article argues that the traditional view is deeply flawed, which of course, I would agree that it's flawed, but probably not in the same way that this guy's going to argue it. Returning to the original sources, especially the court rolls of the Fair Court of St. Ides, that was one of the main courts that perpetuated the law merchant, and of which they took a lot of their quote-unquote customs of this law merchant from. There's a very good treatise on the Fair Court of St. Ides, or sorry, it's not a treatise. It's I think it was a doctoral, it was either a doctoral or master's degree paper that someone had written about the Fair Court of St. Ides. And I'll make a note of that also to put that into the show notes, because it's a very interesting paper on how the Fair Court of St. Ides ran, how unfair it was to anyone who wasn't a merchant, and basically they'd walk in there and just take all your stuff based on their own rules. And that's why it's so ridiculously unfair. So to continue here, anyway, so the most extensive surveying records of this period, it demonstrates that merchants in medieval England were substantially subject to local control. Commercial customs and substantive laws verified significantly across towns and fairs and did not constitute a coherent legal order. Well, there's argument both sides to that one. The traditional interpretation has been retained, not for its accuracy, but for ideological reasons and for its long and self-reinforcing pedigree. This article takes no position on the merits of shielding multinational actors from domestic law. It merely denies that the Middle Ages provided a model for such policies. Again, that's debatable. This is just this guy's opinion. But it's interesting what they get, and I'm not going to, like I said, I'm not going to read the rest of this, but this document is showing you, as you can see here, I'm just going to cover the table of contents here, that it's showing you the history of the law merchant and how it ran, okay? So, merchant autonomy and mercantile courts, voluntarily enforced, enforcement by the abbot, enforcement by the merchants. This is what you usually get. When the bank comes to your house to come steal your house after a foreclosure, this is enforcement by the merchants, okay? They hire their own private mercenaries, literally, to come and throw you out of your house, right? Voluntarily adjudicated, right? Influence of the merchants, influence of the abbot, blah, blah, blah. Voluntarily produced, alternative sources of legal principles, the law of local courts, the status of merchants, and then conclusions on that. Law universal throughout the world. This is where it gets into what the law merchant is within the Court of St. Ides. Mercantile law beyond St. Ides. The lex mercatoria, which I mentioned earlier, the first part. Cities and towns. The counter argument. Royal recognition, conclusions. Merchant law and policies. The civilians in the merchant courts. The romance of the law merchant. Reinterpretation and renewal, conclusions, and then so on and so forth. So, like I said, I'm not going to read all this because it's 128 pages, but I just wanted to give it as a handout so that everybody could take a good look at it. Now, I do have a few notes in here, which is kind of recovering what we talked about in the first section about the historical creation of the law merchant. So for hundreds of years, however, historians have sought from the Middle Ages evidence of an independent, exclusively mercantile legal system as a solution to contemporary problems of foreign trade. Since the early 17th century, the prevailing view has been that fair courts like that of St. Ides enforced a body of law known as the law merchant. This law differed from the municipal laws of the existing jurisdiction in that it was created autonomously by merchants and expressed their customs, reflecting unwritten usages rather than the written command of a sovereign legislature. At the same time, the law merchant was not the product of a single merchant guild or even a single country, but rather universal, the creature of the transnational merchant community. Right? Transnational merchant community. There's your New World Order right there. Establishing substantive principles and convenient procedures to govern commerce across political borders. Yeah, convenient for them. The law merchant thus represented a new legal order, free from the oppressive control of local laws and local lords. Yeah, oppressive from the standpoint that we're not going to allow you to take our lands. We're not going to allow you to trespass upon our rights. To them, that's oppressive. In the words of Levin Goldschmidt, a 19th century German lawyer and historian, quote, out of his own needs and his own views, the merchant of the Middle Ages created the law merchant. Need I say more? Anyway, so everybody can read the rest of this document at their own time and own volition, because we should get going with the rest of it. But it's an important read, and it'll give you a lot more understanding of the law merchant and what it is. So, yeah, exactly. Klaus Schwab says what? Yeah. So the next document we'll have, next time we'll go through here, the outline will be, so we did that, cyberspace. Okay, so an essay on the history of the law merchant. I'll bring that up. We'll take a look at that one. Now, again, this is a fairly long, lengthy book on the law merchant, but again, it's a little bit more modern. So modern from the standpoint that it's not medieval law. So this is 1903, but you see, this is still prior to the this is prior to the Federal Reserve, right? So anyway, you still have this going on prior to the Federal Reserve. So let me get into show you the table of contents here as to what we have. It's a short table of contents, even though it's a 200-page essay. So general characteristics, the rise of the law merchant, courts of the law merchant, persons, sale and contracts, conclusions, so on and so forth, appendixes. Okay, so I have some notes in here. Yeah, I could just read this again, this basic background of what it is. The law merchant has been aptly called the private international law of the Middle Ages. All right, so there you go, private international law. Now, interesting standpoint from what we do with the doc set, when we go into binding arbitration is a kind of aspect of private international law. But the interesting thing about binding arbitration is that it predates Roman civil law. So you can literally use binding arbitration to crush Roman civil law. I won't get into the whole history of Roman civil law and how it evolved from literally being where the praetor, the quote-unquote judge, was basically an arbitrator in Roman times, and then later on morphed into something different. But originally they were just arbitrators, and so binding arbitration predates all of their garbage. So anyway, it was regarded as a kind of just gentium known to all the merchants throughout Christendom, and the later writers who treated the subject laid stress upon its international character. The law merchant, wrote Sir John Davies in the 17th century, quote, as it is part of the law of nature and nations, it is one and the same in all the countries in the world. There is not one law in England, another in France, another in Germany, but the same rules of reason, and the like proceedings are observed in every nation. This statement is too sweeping. Strictly construed, it was not correct for the law as it existed in the 17th century, and it was still less correct for the law merchant in the earlier stages of its evolution. There was during the early Middle Ages no strictly uniform system of mercantile law administrated throughout the whole Western Europe, either in town or seaport or fair. Now, I would disagree, because they're not paying any attention to, whoever wrote this, wasn't paying attention to literally Roman civil law as an aspect of the law merchant. Of course, under the empire, everything was uniform. Of course it was, right? It was only after Rome fell, quote unquote, fell, that you had the system continue to morph and spread and stay in full force and effect even after Rome was, fallen, quote unquote fallen, because technically Rome never really fell. It just morphed itself into even more nefarious bullshit, which we're still dealing with, like the cult of Rome and the Vatican, and so on and so forth, but I won't get into that. So the great fairs of Champagne had their own style, uses, and customs, which were at times altered in important points by royal ordinance. The merchants of Antwerp refused to submit to the law of London. The law of London, notice that. The merchants of Antwerp refused to submit to the law of London. That's referring to the city of London. All right, that's not the king. Okay, that's not the crown. Well, in a certain aspect, it's the crown, because the city of London is where you have the inner temple and middle temple courts of the Knights Templars, which is what the Bar Association is. Okay, and in its numerous lettres de fortes that have recently been discovered at Ypres, I'm not sure how to pronounce that, the alien creditor had always to promise not to recover his debt by any other law than the law of Ypres. In Italy, the several codes of commerce that almost every great city possessed showed greater or smaller discrepancies in almost every section. As a natural result, in several cities, the commercial judges were ordered to give aliens no better law than their own citizens would have in the alien state. So you see that there is like this, it was uniform, but at the same time it wasn't, because again, after Rome fell, it wasn't perfectly uniform because the empire wasn't around anymore. And then you go through the Dark Ages and people lose the capacity for literacy and so on and so forth and blah, 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 blah. But they kept the law merchant all the way through the history, even after Rome fell. So I'm gonna skip down here. I think I have a few more notes in here. I may or may not actually, but I don't want to get into reading all of this in its entirety as I did some of the aspects of the other documents. I just wanted to give a gist of, again, that this is a good document to understand the difference of these. Well, actually, this is an interesting part here. Okay, so the summary nature of its jurisdiction is a second feature that always characterized the lex mercantoria. its justice was prompt, its procedure summary, and often the time within which disputes must be finally settled was narrowly limited. This is where you get this aspect of Roman civil law in our courts doing what they do. Oh, you didn't put the motion in time. Oh, you didn't challenge jurisdiction in time. Oh, you're under our jurisdiction now. There's nothing you can say about it now. You agreed. You consented. You came in and made a general appearance. You're fucked. All right? That's this. That's what they're talking about. To prevent lengthy process, it is not rare to find appeals forbidden. That's the idea of, you can appeal the thing, appeal the thing, appeal the thing, appeal the thing. Guess what? There is no appeal at common law. None. Zero. Doesn't exist. When 12 members of the peerage decide something, that's it. Now, of course, they've bastardized and destroyed the common law so that even though it might look like you're walking into a court that proceeds according to the course of the common law, meaning that you've demanded a jury trial and so on and so forth, they're still going to run it by Roman civil law. And the jury is just advisory, which you'll see the judge go against the jury all the time in these courts, the courts that we have now, because they're not proper courts of record. If you want a proper court of record, you have to file your case as a court in and as a court of record. And guess what? There are still states, Colorado being one of them, and I know there's a few more, that specifically state that the county courts are courts of record and that the district courts are a separate court. So your state district courts are your maritime mammalty, filthy merchant courts. Your county courts are your courts of record. Now, whether they proceed according to the course of the common law or not is up to you being the plaintiff and making sure that they proceed according to the course of the common law and not this filthy lex mercatoria. So, to continue. Speedy justice, in fact, was necessary for merchants, and while the canon law, church, and the usages of the papal chancery, right? Chancery courts? Papal chancery courts? Huh? What? Yeah. I'll get into chancery courts. Well, all right, just as a note here. The jurisdiction of chancery came up in England where the court, the King's Bench, which is basically the common law courts of England, they're referred to as King's Bench, right? Or Queen's Bench now, whoever happens to be ruling. What the attorneys did is they came to the king and they said, hey, king, you seem like you're really busy with your King's Bench. Why don't we create this other court called chancery, of which there'll be a chancellor, and what the chancellor will be the holder of the king's conscience. As if that's even something you could possibly physically do between two human beings. But this was how they created this. That the chancellor would be the holder of the king's conscience. The chancery court had its own seal, and it had the authority of the king, even though it wasn't the king doing what it was doing. Now, where the hell did that all come from? Well, when you look back and see what King John did when he pledged all of England to the filthy Pope, and the barons came back and said, no, that's not happening. We're going to make you sign the Magna Carta or take your head off, right? That whole King John concession, that whole problem, right? That's where you get the aspect of papal chancery courts. Because they all figured, the filthy cult of Rome figured, oh, well, they gave it all to us. All right, so we're going to have these courts now where we're going to hold the king's conscience, because literally we're holding the king now as an infant on his own land, right? So that's where you get chancery court. So I just wanted to give people an understanding of where chancery came from. Okay, so all right, I'll start over. Speedy justice, in fact, was necessary for merchants, and while the canon law and the usages of papal chancery may have furthered the development of this summary procedure in the law merchant, there could be no doubt that it was mainly due to the necessity experienced by the merchants themselves of a speedy settlement of their disputes. This characteristic feature of the law merchant seems especially to have struck 14th century author of the Bristol Treatise, the Lex Mercatoria, which is what I talked about. That this treatise, the Lex Mercatoria, is 14th century. Now, it's not that easy to read. It's actually far more difficult to read than Blackstone's commentaries. However, you can go through it and you can read it, and Blackstone's commentaries being, if you would consider it being like the canonical text of English common law and all of the other systems of law in England at the time, think of the Lex Mercatoria here as being that to the law merchant. Okay. So anyway, so he says in the Lex Mercatoria, he remarks, differs from the common law of the realm in three ways. In the first place, I'm not even going to attempt to to say that Latin. These please, says the Doomsday Book of Ipswich. Oh, well, now I got to get into the Doomsday Book. Okay, so the Doomsday Book was a book that William the Conqueror put down in 1066, or shortly after he took over England. It was the Torrens registry system of the day. So you've got the Doomsday Book, which he put down that said, unless you are in this book, unless you've registered your land in this book, you don't have any rights. It was pretty much precisely what the Romans, it was the Roman system, because it was the exact same thing under the Romans. If you did not have your property or your land registered under the Roman rolls, you did not own it. And that was the aspect of the 9/10 of the law. You know, you ever hear that possession is 9/10 of the law? Okay, what's that last tenth? Nobody ever tells you. The last tenth is that if it's not registered in a Roman roll, you don't actually own it. This filthy idea comes all the way back from Rome, filters its way through the aspect of the Doomsday Book, through William the Conqueror, and now lands in our laps with the Torrens registry system. So you see the progression all the way through. Okay, so I continue. As I said, I'm not even going to try to read all that Latin. The pleas in time of fair between strange and passage soldiery been pleaded from our hour to hour, as well in the forenoon as afternoon. So, okay, and the pleas of the oven to the law maritime, or the law merchant, that is to wit, for strange mariners passant. So those that come up on the shore, they show up and they're mariners and they passant. And for hem, or them, there should be a T there, that abandoneth not, but her tide should be pleaded from tide to tide. So the ebbs and the flows of the tide, that's where you get the aspect of the current. That's why you call it currency, because it is controlled by the banks of the river, the currency, right? From pleaded from tide to tide. All these words interconnect with banks and banking. Okay, so the desire for dispatch expressed himself in many ways, but everywhere the principle is evident. In Italy, almost all commercial statutes of the various cities instructed the judges to use summary procedure. See, you get this whole aspect of summary procedure. That's Roman civil law. You don't have summary procedure at law. Okay, they can't just, here, all your rights are gone, and it's a summary process. Blah. Nope. No, I have substantive rights, and I'm innocent until proven guilty, instead of the reverse of Roman civil law, where you're guilty until you're proven innocent. So yeah. So again, this is just another aspect of the law merchant that I wanted to make sure that you guys could see, and to understand the ebb and the flow part. So again, I'm not going to go through all this. This is 191 pages of this document, but if you decided to sit down and read it, 191 pages, probably take a couple days to go through it if you wanted to get all the rest aspects of the law merchant. And now that I've given you the background of what the law merchant is, it'll be much, much easier for you to be able to read this document and understand how these things still have full force and effect over us today. So from that, let's move on to the next thing, which is I want to show you guys the difference in one of our law books, the difference that where it shows you that Roman civil law is foreign to us. So the next handout will be the preface, the beginning part of Bouvier's Law Dictionary. So here, this is literally the title of Bouvier's Law Dictionary, and this is the reason why you should use this dictionary for everything that you write as an American when you have anything to do with law. Take the definitions from this dictionary, not Black's, not any other dictionary but this one. Another side note with Bouvier's Law Dictionary is that there have been 3 different acts of Congress that specifically say that this is the single dictionary that you should go to when you're looking up anything to do with constitutional law. So, title, a law dictionary adopted to the Constitution and laws of the United States of America and of the several states of the American Union, with references to the civil and other systems of foreign law. Foreign law. So they're telling you right there that civil law, Roman civil law, is foreign to us. So by John Bouvier, so on and so forth, 6th edition, yada, 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 volume 1, right? First laid down September 1839, right? Quite a ways before even the Civil War. So you see how important this law dictionary is, because it shows the common law as our system in the heyday of our system, like during the aspects of common law in its heyday and so on and so forth, but without having too much of an influence as far as the law merchant is concerned regarding central banks and whatnot. So anyway, that's Bouvier's Law Dictionary is the dictionary that you should go to. And like I said, it's in the Vocational Science of Freedom online law library. You can download the entire thing in Word so you can search it. And if anybody doesn't know or isn't familiar with Word, being this as on a Word document, all you have to do is come up here and hit find, and you can type in whatever word you want. You can type in law, and it'll show you all the results of law. So anyway, you type in and then you can just go and find whatever you're looking for in the dictionary. And if you want to, you can squish all the Word documents all together in one single document. They're separated out right now into letters. So you got A, B, C, D, E, F, all the way through the alphabet. But this is the dictionary that you should use when you're understanding American jurisprudence, because American jurisprudence is slightly different than the original English common law. Because why? Because we're sovereign. We're the sovereign, not the king. We're the sovereign. So we're the ones holding our own court. That's the single most important thing when you have to understand the difference between courts of record and courts not of record, right? A court that proceeds according to the courts of the common law and one that does not. You have to understand that that's the basis of it, and that they do not want our courts at all to ever be able to be run ever again, because they don't have any power in them. And in vice versa, we don't have any power in their courts. There's 1,000 presumptions over you, none of which are good for you. So I'll leave that to what it is. You guys can pick up and grab Bouvier's Law Dictionary out of the law library anytime you want. And now let's get into the outline backup, and let's get into the status doc set. So for the first handout, let's open up the handbill for the status docs description. Oh, and one other thing I put into the links here as far as the class docs are concerned, which I didn't have in last time when we did this back in April. I put in the membership for prices, the membership price list for everything. Just wanted to give the price sheet out for everybody. So let's open up the handbill of the status docs description. Get into that. This is the general handbill, which I have for all the status docs. It gives a general outline of what each thing is, and we'll get into the details when we read the actual handbills. But this one is just a short description of the status docs and the estate documents. And again, it follows my color coding, so we went over that before. So this is the name of the document or the task that you have to do, and then this is the description of the document, what it does for you, and what's contained in the document, and the other documents that are connected to it and why. Because this whole entire thing is a whole system. You can't just pick and choose some of these things out of it and decide to do some and not the others. The whole system is created as an entire wall that you put up, an impenetrable wall that you put up, that if anybody tries to climb over it, they're stuck to the contract without question. So the first one is the house seal, the seal notice. This is where everyone wants to make a record and publish their seal of their own house. And so that all of the contracts that you seal are also considered to be covenants in law, which are higher than regular contracts. So at law, you have a contract, and then you have a covenant. A covenant is a contract under seal, and there is literally an action at law called covenant, where if you violate a covenant, you can bring an action of law called covenant, and it's a more severe action, if you will, at law than just a violation of a contract, right? So it's dishonoring a seal, and that aspect of honor and dishonor plays into that particular type of claim at law. So anyway, so that's that. Also, the seal notice puts a blanket of doubt over all contracts within the law merchant that you or any attorney has ever signed regarding your estate. You see, the attorney, what they do, because you're an infant and you're abandoned and so on and so forth, what they do is they take power of attorney over you as your administrator. And when you say fill out the bonding information, which we also have templates for, if you fill out the bonding information for your court case and you do a state Open Records Request Act for the bonding information on a particular case, you'll see or at least we've seen, when you get back the bonding information, you'll see that the attorney creates these bonds on the court cases by power of attorney. You don't even know that these things are getting created on your estate, right? Unless you do the type of FOIA request and stuff that we have available, which I'll get into later in the day. You can ask for the bonding information from any case, and when you get the bonding information, then you can call the bonding company and cancel the bond. It's your estate. They're bonding your estate. So if you call the bonding company and say, that's my estate, I'm the executor of that estate, and then you show them the executor appointment, which is one of the status docs down here. So when you show them the executor appointment, say, look, this has been recorded on the public record. The person who signed this is not the executor of the estate. I want you to cancel the bond. You cancel the bond, you cancel the case. That's law merchant. That's the law merchant for you. They bond every case. Why? Because they don't want liability. So if you strip them of their limited liability, they will not mess with you. Then they get full liability, not only just from the standpoint of the common law, but they get an extra $300 million of liability on their ass from the status doc set, which gets them run over from kill warrant, which is the affectionate name of what we call lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders of same, or for same. We call this large title, we just call it the kill warrant. That's a mouthful to put out every single time you want to reference the doc. So anyway, so that's the house seal. We'll go through all of the handbills in these one at a time here. Birth certificate authentication. This is something that you do at both the state and federal level. So what you do is you get a copy of your birth certificate from the county recorder's office. It'll usually have the county seal on it. So it basically comes, quote unquote, authenticated from the county. And then you send it off to the state. And depending on what state you got to send it off to, they will have different processes for getting it done. We don't have all of them, meaning I'm not sure I have a process for every single state, but it's very easy to find. What you do is you get online and you search through the Secretary of State's website and you search for authentication of public record. And the Secretary of State will usually have a form. Michigan, however, does not have a form. All they want you to do is just write a letter. So you just write a letter, which we have for Michigan. We have a template for that. And you just send it into the state, and they put on their authentication, and they'll rivet it to the birth certificate, and that's your state authentication. And then you turn around after you get that back, and then you send it off to the feds, the Fed Secretary of State, for your BC authentication to get it back from the feds. And sometimes it takes longer than others. We're not exactly sure why sometimes things take longer than others do when it comes to getting the authentication back from the feds. Some people get it back within a couple of weeks. Some people, it seems like it takes months. And I honestly, it's probably workload, but if you don't get it back within a reasonable amount of time, and I would say a reasonable amount of time would be about a month, anything past a month, I would start bugging them. I'd start knocking on their door and saying, hey, I sent this in a while ago. What's the status? Is it coming? Is it not? Did you lose it? What's going on here? So that's that. That's the authentication, both state and federal. So we have the whole process of that. And that's something you have to do because you have to get the authenticated BC from the feds. And federal authentication on the birth certificate shows you is that in a block of law on the BC that this document is as good as the original. Because the original is actually sitting, from what we understand, is sitting at the DTCC, which is the Depository Trust Company and Clearinghouse in 55 Water Street, New York, New York, which is why when Q talked about everything ends at number 55, that's what he was talking about. If we take everything back from them out of the DTCC, then they don't have anything. They have nothing. There's nothing that they can do. If every single American claimed their estate, this whole entire system would end tomorrow. They'd be left with literally nothing. So anyway, so that's the BC audits that you got to get done. So that's that. The seal notice, talked about that. That's where you put it up into clear your house seal. Judicial coroner appointment. This is where you appoint your judicial coroner. Somebody asked me the other day, does the judicial coroner have to have their own house seal as well? It's preferable that they do, but it would not in any way, shape, or form negate the validity of the document. If you got, say, your friend who was a doctor, or your friend who was a paramedic, or anybody else in the medical field, you can have chiropractor do it. It's fine, as long as they have some sort of medical license. Doesn't really matter what it is. You can appoint them as your judicial coroner of your own house. Because you, as a sovereign, have the right to appoint whoever the hell you want to your own court. And that's clearly still seen to this day, even in maritime admiralty, in the Federal Rules of Civil Procedure, where it talks about the appointment of special masters. A special master is someone that you can appoint to your own court who is kind of like a judge without the pay, more or less. And you can ask the special master, you can delegate the special master to do all kinds of things in your court. And so anyway, the point is that even the Federal Rules of Civil Procedure still show this ancient right to be able to appoint whoever you want to your own court. And that's what we do with the judicial coroner appointment. We appoint a judicial coroner who then has the capacity to say, yes, I found this man to be living. I found this man to have come of full age. And then what they do is they also sign off on the coroner proof of life and proof of age inquest. This is where you get the coroner proof of life and proof of age inquest is what you need to get done for the 12 other people sign off on. This is where you have a petite jury sign off of the fact that, yes, you've come of full age, you've been found to be living, as per the Magna Carta, that you are competent to handle your own affairs, and that you're not an infant under 1 USC 8 person, right? So that you've come of full age. And so you get the judicial coroner appointment. The coroner then convenes the petite jury, which is just other members of the peerage, right? Which are other members of the sovereignty, which, of course, that's the whole point of that too. A member of the peerage does not mean you're equal. It means another fellow member of the sovereignty. Now, not to say that's not your equal. That's not what I'm getting at. Just do not confuse the term a member of one of your peers to mean, oh, it's your equal, meaning like, oh, it's your fellow citizen of the United States. No. It means a fellow member of the sovereignty. That's what a peer is. That's what a member of the peerage is, okay? So when you have 12 other people that are willing to sign off on this to say, yep, this is what I am. Honestly, there isn't, we've thought about doing it online, meaning that you shouldn't have to meet, but if you can get 12 people to meet and sign off on it, it's certainly a lot better. Now, you could do a round robin. I suppose you could do a round robin letter bounce. So if you all met online and you had the judicial coroner sign off on it and everybody saw you on a live screen, right? Clearly, if you can handle your friends, so they can see how old you are, so on and so forth, and the judicial coroner signs off on it, and you maybe go through. There's an aspects of facts that are listed in the proof of age inquest that you could do that online if you wanted to. I think in a weird way, this pandemic is actually in a weird way forcing us to come into our own right in how we can manage our courts of record, how we can get very advanced at doing the doc set. But yes, I agree with what both you guys are saying. It's better to be in propria persona to sign the docs physically, clearly, because you also have to put your seal on them. And yeah, mailing them around would be slow, but if I'm just saying for the people that have absolutely no other, but that's the point. There should never be a situation where we're not having a group of at least 12 members of the peerage to help us. I mean, that's literally the point of getting the rest of the recruiting. You know, you want to have, well, you ultimately want to get to 25, or 30 is probably preferable. You want to get to 30 members of the peerage in each county so that then you can have your grand jury. Because if you listen to the grand jury classes on the Vocational Science of Freedom YouTube, you'll realize that all of your power is fully in the grand jury. You can do damn near whatever you want to do when you convene a grand jury. You can subpoena documents. You can do anything you want to a corporation. And remember, all of these governments are just corporations. That's all they are. They're just corporations on the law merchant. So anyway, that's a little aside for that. So to continue, so that's how you do the coroner proof of life, proof of age inquest. The BC claim claims your authenticated birth certificate, so you have to get it authenticated both state and federal. You file the BC claim, which you take the authenticated version of the BC and you attach it to the BC claim, so that you're claiming it and saying that's mine. The executor/executrix appointment, that establishes you as the executor or executrix over your estate. And yeah, and you're right, Blue Star. Everybody does need to be part and parcel of everybody else's status doc process so that we have a clear group. And if we do the mail thing, at least it could be a clear group between the various different members of the vocational science of freedom so that we're absolutely sure that we can, we're trusting when we're sending them. And we've done this before with other members, and we've done it with people in Iowa and some in Colorado and so forth that we mailed back and forth, which worked out fine. It just takes time. So the executor appointment, as I said, places on the public record that you're the executor of the estate. And also if you do the SS4 form, then you have a letter from the IRS saying that you're the executor. The rescission of power of attorney, this is the one that's important because it ends all contracts known and unknown that have ever been created by power of attorney over you or your estate and any trust that derives any value from the res of your estate. There are many POAs that exist in many contracts that people have entered into, both state, federal, and by corporations and by attorneys that they just don't know they're there. And so what that does is it takes care of all of the presumptions of any power of attorney, like as I said, with the court bonds. The court bonds are something that are done by power of attorney, and once you file your rescission of power of attorney, any other court case that ever comes up, honestly, you can pretty much stand on the rescission of power of attorney by placing it into the court record and say, look, I don't know what you guys are doing. You don't have power of attorney over me because I revoked it a long time ago, annulled it, and I'm the executor. So any bonds that you created, that's fraud. And fraud is the one word that they avoid like the plague, literally. So that's the rescission of power of attorney. The fee schedule, we then have a fee schedule in place that establishes lawful fees that are payable to the executor of the estate for any trespass, use, administration, and orders given from anyone other than the lawful executor of the estate. This is a secondary contract to the KW and should be served on all trustees of the estate. It's above and beyond the $300 million bond, which is in the KW. And it also covers extra things if you want to simply create a bill, a true bill, and give it to them of anyone who attempts to administer the estate, which would be anybody that gives you an order, right? Think about it. If you walk into a restaurant, what do? You place an order with the waitress. You give her an order. Go get me this. Okay. So she go gets you that, and then what does she do after you're done? She presents you with what? A bill. So if somebody gives you an order, you have the right to present a bill. Okay, that's no different than a cop on the side of the road. It's no different than a land pirate or a judge or just anybody. Doesn't matter. Anybody that gives you an order in a common law jurisdiction, you can present them with a bill. And then you can stand on it and say, nope, I had a witness. He gave me an order. I followed his order, but he gets a bill. And trust me, they're not going to like the amount for the fees in the fee schedule because they're all based in gold and silver. So then we get into the kill warrant. This is lawful claim of title, so on and so forth, blah, blah. This is the center doc of all the rest of the status docs. It offers the office of trustee to all others in the world that are not members of your own house and gives them terms and conditions of that appointment and the means by which they agree to them with enforcement by binding arbitration or court of record proceedings. There are dozens of contracts and situations of which, like I said, we don't know that we're entering into. However, when you offer them a contract and say, okay, let's give an example like this. If you say to let's say somebody comes up and knocks on your door and says, hey, I'd like to paint your house. And you're like, well, yeah, my house kind of does need painting. And so you guys agree that the house needs to be painted, the amount of lawful consideration that you're going to exchange for that service of the painter. And the painter says, great. And you guys put into the contract, you write into the contract, it says, this contract only enters into full force and effect when the painter or so-and-so begins painting the house. Right? So that's what the contract says. Okay. If the painter never comes and starts painting the house, he is not under obligation to ever start painting the house, if that's how you wrote it in the contract. Because contract creates law. When you write a contract, you are writing law. The law between the parties. The agreement of the law between the parties. That's what you're doing in a contract. Why do you think these contracts that you sign for like user end agreements and all this other shit that you end up doing, whether it be for software or whatever else, are so ridiculously lengthy? You ever read one of those things? Because what they're doing is they're stripping you of all your rights. Well, guess what? What's good for the goose is what? Good for the gander. You can do the same thing to them. And it will be upheld. It's the same idea. You just reverse the whole thing back onto them, right? So when they come, and in the example, so when they come to paint the house, now they've entered into the contract. What the kill warrant says is that when they administer the estate, they've agreed to be a trustee of the estate. Because you're sure as damn well not going to be the executor, and you're sure as hell not the heir. Right? So you then become the bitch position, which is a trustee. And then they have to follow all the executive orders that are in the kill warrant as a bound trustee. And they have a certain amount of time to do them, and if they obey them, then fine, they don't have to post their bond. But if they don't obey them, and if they don't do it within a certain time, then the bond is automatic, and even if they haven't posted it, they agree to be bound to a $300 million level of liability, whether they posted the bond or not. So literally what it means is you get to take it out of their ass. And there's someone in Colorado already who has a binding arbitration award against state judges. He recorded that award onto the county land records, and he now has a document from the Secretary of State of Colorado that actually shows that he has a lien on a judge's house. So this process works, and the last bit of the process is that we'll probably end up doing is that we'll probably end up foreclosing on the lien, most likely. Or if we get the Colorado Supreme Court to confirm the award. Now, confirmation is not required. What you're doing with a confirmation of an award, and I'll get more into this into the latter part of the day when we're going over the arbitration process, but just for time being, an award is a judgment. So you have a judgment in a binding arbitration proceeding. You can then use that judgment to sue out something. You can then, sue it out, right? And confirmation of a court of a binding arbitration award is just asking that particular court, that particular court's enforcement power, if you will, to enforce the award. That's all you're doing with a confirmation. You can go enforce the award on your own, on your own volition if you want to. The trouble is that in this day and age, with everybody being so stupid about the law, particularly sheriff people and whatever, is that if you walk up to a judge's house with an award and say, get out of the house, well, we all know how that's going to work. So what we're doing is we're going to just go through the processes of suing it out through either court of record, having a grand jury or a petite jury confirm the award, and then writing out and doing either writs of execution or writs of garnishment, or in the alternative, filing foreclosure on the lien. So those are the various different ways we'll finally we'll take the judge's house right out from under his feet. So yeah, you guys are talking about CLF3's little questionnaire to the cops. Yeah, that's a good one to drop with the fee schedule. But yeah, they have to answer all these various different things, or else basically they can't talk to you, which is kind of a fun document. Okay, so to continue here with the status docs. And then it goes on from the kill warrant, and then we get to the Declaration of Oath and Citizenship. This declares on the public record your true state citizenship and disavows any allegiance to any foreign power and the federal corporate government. This doc is used in connection with getting a state passport that does not have to have a Social Security attached to it. The Declaration of Oath and Citizenship makes sure that it's clear once and for all on the public record what you are. You are one of the people, you're an American, you're Wisconsinite, however it's stated in the style manuals, and you're not any of the other things that they presume you to be. A resident, a citizen of the United States, a government employee, any of those other things that you really don't want to be. Pretty much knocks that out of the park. So that's it. That's the Declaration of Oath and Citizenship. Then you have the Ordinance of the Estate. The Ordinance of the Estate is just a simple one-page doc that has all of your other status doc named by public record number in it for easy notice to be given to all others without having to serve the entire doc set on a trustee. So you can literally just fill out the Ordinance of the Estate, put it onto public record, which will have all of the rest of your public record numbers on it, meaning all the rest of the status docs. And then you can just serve the Ordinance of the Estate, and they have to do their due diligence as to go to the public record and look up what those contracts say. It's a way of helping people that are financial struggle, kind of, and so that they don't have to pay a tremendous amount of money to get certified copies and so on and so forth. But there was an interesting story that happened with Blue Star in Michigan, where him and his wife walked into a county recorder's office, and they didn't tell me that when they called me, they didn't tell me that I was on speakerphone. And so anyway, they were dealing with the clerk, and they were hustling and fussling over, well, we record these documents, and what is this, and what are you doing here, and with the status docs, and oh, we need to charge you a fee, and so on and so forth. And again, I didn't know I was on speakerphone, and I said out loud over the phone, I said, demand that he produce the law upon which he relied to make the assertion that he can deny you access to the public record. And the clerk heard that over the phone and apparently slapped the assistant clerk and said, file whatever they want, no charge. And so Blue Star's been able to go back to that county recorder and record whatever the hell he wants to, and they don't charge him anymore. Simply because I said that statement over the phone, and he stood firm as to the fact that, no, I don't have to pay for this. This is public record. This is ridiculous. And so that's one funny little story as far as that. Yeah, you can get the county recorders to file for free if you know what to say to them, right? And of course, or get in there, start talking to them, and then call me, and I'll say that sentence and sound like an attorney, which is probably what freaked them out. But anyway, yeah. So you can get your documents recorded without fee. And at least we can certainly get them recorded in Michigan without fee. So anyway, the next one down. So the rest of these, so that's the ordinance of the state. That's basically, there'll be one last final status doc, which we're actually working on right now, it'll be a common law, kind of a common law mandamus, if you will, sort of, but it's not exactly in the same spirit of mandamus. What it basically will be is that when you have your 12 together, when you have your 12 other members of the peerage together, what this final doc will be is that they will sign off on the fact that you have claimed your estate and that you have sued out your livery by acknowledging all of the rest of these documents to be true and correct, that you are the sole lawful heir of your estate, and by the common law and a decree of 12 members of the peerage, along with the judicial coroner signing off on it, that you have sued out your livery. Because the reason we can do this is because if you read the Magna Carta, it clearly states in the Magna Carta that matters of life and limb shall be considered gratis and cannot be denied. Okay, so what does that mean? It means that when your life depends on your own estate, which is literally how it's written in the Sesquique Act as well, it says, upon whose life or lives the estate doth depend, you're proving that this is a matter of life and limb. You're saying, no, my life depends on my estate, obviously, because it's everything that I own in law. So because of that, we can do this, and it has to be considered gratis, and we can do it under the common law without ever having to wander into one of their filthy Roman civil law merchant courts ever again. And it's all we should ever have had to do. Well, we never should have had to do this anyway, but the point is that it's the best way to take care of it as far as correcting the public record is concerned. Then if you want to open a formal probate case and just drop all this into a formal probate case and be like, hi, I'm here to claim my estate, and now I want letters executor from the formal probate court in the law, from a law merchant maritime amnesty standpoint of it, to force them to do their inferior process to give you a letters executor. That's fine. You can do that too after the fact, after you've gotten all the rest of this done. So that's pretty much where the status doc set ends. And then the rest of these documents are things that we offer that we can do for you, but that are not an essential part of the status doc set itself. I do include the special master appointment, marshal appointment, if you have any immediate need to go to court. Like these templates are included in the status doc set, but I won't fill them out because they're specific to not only your court, but your situation, who you want a special master or marshal, and so on and so forth. But they're very self-explanatory as to how to fill them out. And then the will docs, also I have these, but again, someone's will from a standpoint of what you want to happen with your estate property after you pass is also very specific to one scenario. And so there's no way that I could have a blank template for that. So even though I kind of have templates, you'll have to alter them as you see fit, because the templates that I have are pretty much on a basis of Christendom, and you might not be a Christian. Like for me, I'm a Taoist. So, I'd have to rewrite them and say it slightly different than how they were written. But they're a good general layout for the will doc. So we have those available. And then we have the state passport application, which I spoke of. The change of address to general delivery, that's just more along the lines of something we don't do for you, but it's just something that we can explain to you how to do. The SS4 form, which I covered and spoke about. And then we have the Declaration of Allodial Lands, which, as I said, I think I'll do a whole entire class just on the Declaration of Allodial Lands, the history of it, and just all of it. Because land it's such an important topic, and it's so essential to our freedom to own our own land that it warrants to have an entire day class just on land history and allodial title. So that's the simple short handbill description of the status docs. Now we'll get into the general handbill, which is more of the who, what, when, where, why. This is the document that we're going to be covering, the general handbill for status docs 1.5. And it will take us through how to do your VSOF status doc set after we at the Vocational Science of Freedom have created the doc set for you. And the status docs for the VSOF are 21 rounds of silver. They will always be 21 rounds of silver because an ounce of silver is actually considered $1 under the Banking Act. So we always deal in lawful consideration in the Vocational Science of Freedom. So if you'd like to have your Vocational Science Freedom Status Doc set done, it's 21 ounces of silver. And you can also find the link to the prices also in that same mega link right here. It's 0.5 VSOF prices for membership and docs and classes, 3.6. Okay, so let's get into this and I'll show you how this works, guys. All right, so handbill for the Vocational Science Freedom Status Documents. The Vocational Science of Freedom Status Documents have been created and developed over the course of 20 years. Some of the documents have gone through over 400 updates. Actually, now some of them have gone over 140 updates and edits. And when you purchase your doc set from the VSOF, the documents are filled out properly by us, and then they're emailed to you so that you can sign and seal them correctly with the proper witnesses and other parties. And they come to you in a locked PDF form, and you can print off as many copies as you want, but you cannot change them. They're perfect as they are. There's nothing that needs to be added to them aside from your signatures and your house seal. That's it. Okay? So follow the handbills that are given to you in order to get this entire process done correctly. Because if you alter the process in any way, shape, or form, well, then I can't in any way, shape, or form determine whether you're going to be successful in what you're doing because you did something else that I didn't know and you changed or altered the path of what we're saying to do here. So to continue, none of these documents are to be altered or filled out by any other than the VSOF. If you have not received your status docs directly from the Vocational Science of Freedom, and you can email the VSOF at vsof@protonmail.com, then there is a 100% certainty that they are incorrect. There have been people that have been trying to grab, steal, and use the Vocational Science Freedom Status Doc set. The VSOF Status Docs are a complete set. They all work together. If you do not do them all as a complete group, you're not going to be having all of the protections that they afford. And this goes for all quote-unquote gurus out there. Anna Von Dipshit stole documents from the VSOF years ago and butchered them and put them out for people to not be successful with, obviously. So that's a little note on do not change, do not alter. Just follow the instructions and you'll get it done, okay? All right, next section. The VSOF status documents are used to correct the state and federal public records, probate records, and private records of your house as they pertain to who you are in relation to the government, both state and federal. What the VSOF status docs also do is put your will onto the public record regarding the unlawful administration of your estate. All of the people's estates are being administered under several presumptions. These are but a few. One, that you are dead and therefore dead to the law, that your parents abandoned you at the foundling hospital,
that you have not come of full age and are therefore seen as an infant in all courts and unable to handle your own affairs. And this can also be seen in the definition of person under 1 U.S.C. subsection 8. And that you are incompetent and must have your estate managed for you. Much of this administration was the result of many unlawful acts being passed during the quote-unquote New Deal. In that time, the state governors committed treason against the people of the states in 1933 and unlawfully pledged all the property that the people had registered with the state. This was done so that Congress and the federal government could pledge that property of the people to a private banking cartel run by the Khazarian mob known as the Federal Reserve System. The property of the people, including but not limited to your body, is being used as collateral to the Federal Reserve System. I should put a "the" in there, for the creation of the fiat currency, banknotes, also known as Federal Reserve notes. A lengthy overview of what happened was revealed in a quote from a man who was Woodrow Wilson's handler, and that man's name was Edward Mandell House. This VSOF class explains what happened during this time in America in history and why, and there's a link right there. Of course, you can click on it, and that'll take you to the Edward Mandell House quote, how basically he stole the Republic and what they did in 33. A much deeper dive into history than just what I could put into one paragraph. To continue, regarding some of the presumptions that the attorney holds over you. The presumption of death kicks in after 7 years of no one coming to claim you at the foundling hospital and that your mother abandoned you when she signed your birth certificate contract. The infancy presumption stays in full force and effect until you, quote-unquote, come of full age, as contemplated in the Magna Carta in Articles 3, 4, and 5, which I highly suggest everybody go read the totality of the Magna Carta, but for this particular class, focus on reading 3, 4, and 5. You'll see what I'm talking about, which is still the common law to this day in America, meaning the Magna Carta. And the incompetency presumption also stays in effect until you correct the public record, make a proper claim to your state. And that's the all capital letters name on your birth certificate. Now, it's not necessarily always an all capital letters name on the birth certificate. The name of the estate is whatever the name is on the birth certificate. So you could have a proper name of John Henry, but the last name on the birth certificate might be in all caps, all caps Doe, right? Or it might be John Henry Doe, all caps. Or it might be John Henry Doe, upper and lower case. I don't care what it is, but the name on the birth certificate is the name of the estate that was registered, because that birth certificate is on bond paper. It is a negotiable instrument. So you have to write it exactly as it is. Well, you don't have to. We take care of that, because that's one of the things that I had the biggest problem with people understanding what they had to do. A lot of people were just putting the all capital letters name down, and I said, is that what your birth certificate says? And they said, I don't know. I said, did you file the handbill? Well, I thought it was just the name of the estate. So anyway, that's just one of the many reasons why I'm the only one that ever does anybody's status doc sets anymore. Just me. That's it. They're done. They're given to you perfectly, and they're correct. And we send you a questionnaire before we do them. And that questionnaire is also in the mega folder for this particular class, and it's right here. It's 1.2 checklist of personal info needed for VSOF to do your status docs. This is what you send back to us at vsof@protonmail.com to have your status docs sent, as long as you've also paid your 21 rounds in silver to the P.O. box, which is listed in the prices and membership info handbill. Okay. So as I said, they come back to you in a locked PDF, and they're correct. So the aspect of suing out your state, I'll just restart here. Okay. And the incompetency presumption also stays in effect until you correct the public record, make proper claim to your state, the all caps name, or whatever it says, on your birth certificate, and sue out your livery of your estate in the proof of life and proof of age inquest, which is part of the status doc set. This is a practice that was well known during the times of the Court of Wards and Liveries in England, but has been purposefully occulted from us so that we never have the ability to make proper claim to what is ours. Now, these three are the main presumptions working against you. This is an expanded list of other presumptions that the attorney uses against you. List of presumptions. And these are all, again, all these presumptions are rebutted in the status doc set. 1, that you have not been found to be living and are a decedent under the IRS code or dead to your own estate under the common law. 2, that you have not come of full age and are an infant under 1 U.S.C. subsection 8 person and therefore not able to handle your own affairs. And once these are abutted, they are now required to give your entire estate, as per Articles 3, 4, and 5 of the Magna Carta, without fine and without fee. And just to make another note here about the aspect of the infancy presumption, infants cannot hold title. Okay. So if you're still considered an infant, you can't hold title to anything, which is why they make you register everything, like your cars and your house and your land and your weapons and your children, right? Because you can't hold title. An infant cannot hold title. You must come of full age, then you can hold title, not before then. Number 3, that you were not born of parents that were in wedlock when you were born, and therefore you are a bastard, and therefore are unable to inherit under the common law. This presumption strips you of your status as heir to the protections of the Constitution, as in to ourselves and our posterity, right? You can't be a member of the posterity if you don't have the right under common law to inherit, and bastards don't. And the Khazarian mob, Luciferians, know this. So they set up a system that creates all these presumptions that you never know about and you think you have to go along with, but you don't, as long as you correct them. Number 4, that you are not the sole lawfully appointed absolute general rightful executor of your own estate, which is, again, the all capital letters name that they charge under the statute merchant. This is not a corporation, by the way, and it never has been. It is a fiction of law, and some of the property of said can sometimes be placed into a trust with other names, like whatever your Social Security trust name might be, which is usually, but not always, something like Henry J. period Doe, meaning Henry John Doe, but Henry J. period Doe, usually all caps. That's usually how they name the Social Security trust, but not always. Number 5, that you tell the IRS by proper document of number 4 above. 6, that you tell the IRS to give you a proper 32 EIN estate number so that you can open a bank account as the executor and settle the entire gross estate. 7, that you are a trustee of your own estate, meaning that there's a presumption that when you walk into court, they see you as a trustee of your own estate, which is ridiculous. But that's why they can tell you, oh, you can't put this in your body, you can't put that in your body. You can't drive over 55 miles an hour down the roads, right? That kind of thing, because you're an infant. So they treat you as a trustee of your own estate and your own property so that they can control you. And but that's not what you want to be. You always want to say that you are the sole lawful executor and heir of your estate. And that to rebut this point, everyone and everything not of your house as trustees of said estate, and force them to post bond in case of unlawful administration of the estate or fiduciary malfeasance on their part, and appoint yourself as the sole lawful executor of same. So what we're doing is we're saying, look, we're appointing everyone who's not a member of our own house on the entire planet. I don't care who it is, fiction of law or otherwise. We appoint everyone else a trustee, except the members of your own house. So everyone else is a trustee except the members of your own house. Then if anyone comes along and starts to administer your estate, your property, you say, okay, I've noticed you already that if you did this, you would be accepting this contract. And that contract is lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders for same. This is what we affectionately call the kill warrant, or even shorter than that, just the KW. And this was the document that recently came to my attention that David Straight was giving out to people, which, having no idea how to use it, he was, I'm sure, making matters worse for everyone, which is, of course, what he does because he is an agent. Number 8, that you are not one of the people in relation to the state you were born at and in relation to the federal government. Claiming to be one of the people in all of your documents is all that needs to be said to claim your sovereignty over the filthy corporation state, which has no sovereign immunity at all because they are all operating in commerce. And municipalities don't have any 11th Amendment immunity because they have separate purses from the state. So they do not have what the cops and pigs call, we have qualified immunity. No, you don't. You work for a private corporation. You have no immunity at all. Number 9, that you remove the presumption that allows them any power of attorney over you at any time for any reason. The status doc that accomplishes this is the revocation of all power and letters of attorney. This is important because what they do every single time that you go to a court, they create bonds on you, and they create them by power of attorney. We have proof of this because people have gotten back their bond information from courts, and it comes along with, guess what? A fully filled out power of attorney form. So yeah, they're just making money off your estates because you're too stupid to go and actually make the claim. That's why you're a slave. That's why their system works. That's why we need to end their system by taking everything back from them, and then they'll just wither away and die because all they are is parasites. So if everyone would do this tomorrow, there would be no more United States federal corporation. There would be no more municipalities, little corporations of littler corporations trying to control you because they wouldn't have anything to administer. Okay. 10. The presumption that you want any benefit from them at any time for any reason. You do not want to be the beneficiary. You want to be the sole lawful heir of your own estate. If you take a benefit from your own estate, you're inadvertently waiving your rights as the heir of that estate, for the heir is the more powerful and proper status to have instead of beneficiary. If you don't believe me, go look up a term. It's called beneficium abstinente. Go look it up in Blacks and read it. Number 11, that you are subject to statutes, acts, ordinances, or codes, which are all aspects of Roman civil law, also known as municipal law. You only get in this bullshit if you are contractually bound to it in some way, shape, or form. Even if those contractions and those contracts and those pledges are something that you didn't even ever know got entered into because you were an infant at the time and you didn't have any volition or any say in the matter. But again, these are presumptions and things that happened before you even had the cognitive wherewithal to know that they were happening. So we as sovereign Americans only uphold all public, common, and natural law and are not subject to the filthy law merchant, maritime mammalty law, military law, ecclesiastical law, or equity, unless a valid contract, trust, pledge, bond, or oath, or agreement can be brought forward to prove otherwise. Number 12, the presumption that you are bound to any unrevealed contracts, trust, pledges, bonds, or oaths that they hold over you as an infant. For no contract that you may have had with the corporate government can ever be valid because if you used Federal Reserve notes at any time for the quote-unquote contract, i.e. license, it voids that contract for lack of valid consideration. If you don't believe that, just go read the Jerome Daly case, also known as the Credit River decision. Number 13, that your estate is considered abandoned, not claimed, and therefore requires administration. We don't know where you are. You're lost at sea. You're dead. Oh, I guess we have to administer. Right. Exactly the same thing that they did in Rome with the 12 tables after they burned Rome to the ground. Exactly the same thing that they did to London after they burned London to the ground and then initiated the Cestui Que Act of 1666. Saying unless you have been found to be living in an action, the crown gets to administer everything. No different back in Rome when Caesar said the same bullshit. 14, that the presumption that anyone has come forward with a superior claim to your estate, meaning you're the only sole lawful heir. So how can the state act as an heir, even though that's exactly what they fucking say in all of the uniform probate codes? The filthy Luciferian attorney has gone so far as to make the presumption that the state is the heir. Oh, really? How did that happen? A fiction of law all of a sudden becomes an heir? No, that's impossible, you morons. Because corporations can only have successors. They cannot have heirs. Only living beings can have heirs. Now, we can have assignees as well, meaning, okay, we want to give, say, our grand piano to our youngest nephew or something. Fine. Or to our neighbor who isn't of our sanguinity. Fine. You can do that. No problem. But you have heirs, not successors. Corporations have successors and not heirs. And I don't care what kind of corporation it is, whether it's a corporation sole, like the Pope, or whether it's U.S. Bank. It doesn't make any difference. It's irrelevant. Okay? So, if no one has done so, meaning made the claim to your estate, you place first and highest claim on your own estate, or you must let go and lose any claim over same. Or sorry, they must let go or lose any claim over same. So they can't come forward with a superior claim. You say, I've claimed this. Anybody else got a superior one? Nope. Okay. Then they must let go and lose any claim over your estate. Because you're saying, I now have it, meaning I own it. I've taken dominion over it. I have title. I have lawful title, and I claim lawful title. Now you must have a higher claim or get off my shoes. Stop stepping on my feet and get off my back, monkey, because you don't belong there. You're nothing but a parasite. So, 15, the presumption that you consent to any administration of your estate. And 16, the presumption that you are a 14th Amendment citizen, subject to the jurisdiction of the corporate Congress in D.C. and not one of the people of your own respective states. And there are other presumptions listed that I'm not going to go through, but these are the major ones that are rebutted. There's a lot more in there, and I wasn't going to make an absolute exhaustive list because I had to go through every single status doc, but you get the point. Okay. So now on to what are we doing? So after you get back your VSOF Status Doc set, the order of the process in which to finish and file the VSOF Status Doc set is as follows. And again, this is the link for the handbills is right here, same one that I put into chat before. So first thing you do not have to wait for your authenticated birth certificates to come back from the state and feds before you start this process. You can get things done. I can get your doc set done completely and back to you by the time your authenticated birth certificates, because you get your birth certificate first authenticated on the state level, then you send it to the feds, and then they authenticate it a second time. And then that's when it comes with that fun little block of law in the lower left-hand corner, which I have discussed before. But needless to say, in short, part of it says that this document is now as good as the original. Okay, where is your original BC? It's sitting at 55 Water Street, New York, New York, also called the Tower of Power. That's the DTCC, of which, if anybody remembers this, Q said this all ends at number 55. Well, if anybody like us were listening, we knew exactly what he was talking about. And Q also said, follow the water. Right. This is all based upon maritime admiralty salvage laws. And that, oh, you're lost or abandoned. We don't know where you are. Oh, I guess we'll just pick you up as salvage now and administer you the rest of your life. Right. Okay. So that having been said, that's where your original is. So when you get your duly authenticated BCs back, one of them gets attached to one of these documents down here, which is the BC claim, but we'll get that in a second. So the first thing you do is you can go get your house seal made. So you get it from any office supply store. And again, all of the handbills for each and every one of these things is listed in the same folder, but it's in a separate folder. It's here. So it's where it says start here, handbills for each of the VSOF status docs. If you open this up, this will then take you through all of the rest of the process. So again, you open this up, first thing you do, start here, get the BCs authenticated. Then what do you get back from authentication? And then, well, actually, you know what? I'll open this up real quick just to show you guys if it'll open from Mega, which I think it will, possibly. Or wait, it might. No, never mind. It was trying to download it. I guess I can't open it directly from. But anyway, so what I was going to say was this document right here, authenticated BC from Secretary of State. This I made in exact format and exact font size as to what does get attached to your BC when it comes back from the feds, just to give you guys an example of what you should see when it comes back. So again, start here, authenticate them. When you get back, and then how to make your house seal. So the handbills of how to make your house seal are in here. There's some samples of seals, obviously, like what it can look like. And this tells you how to make your house seal. So after you've made your house seal, then what you do is you can then go to a office supply store and you go and you say, I'd like a corporate seal made. And you want to get the corporate seal about you want it 1.5, no smaller than 1.5 inches, and you want it no bigger than 2.5 inches, or else when you start to get to 3-inch seals, they're just way too unruly, and there's not enough space on the VSOF status docs for that to be anyway. The VSOF status docs are made for 1.5 to 2-inch seals, so just long so everybody knows that. So you get your house seal done. Number 2, and I have this as 3, but again, just for those that are listening to this, you can deal with 2. I always said to get 3 because I say, okay, you send one off onto your status docs, and then the other 2 we can use later for other potential reasons, either to use it as an exhibit in formal probate, or possibly use it as another form of a check, because that's what the BCs are. They're all considered checks. And to endorse it again, if we have to send it to possibly the DTCC with the entire full status doc set saying, look, we want our entire gross estate back, if there was some need to do that. So really, you can be just fine with getting 2 and getting 2 authenticated. You really don't need to get 3. So I should have changed that, but okay. So you get those back, and this is how you properly get them authenticated. Number 3, when you get your house seal back from the office supply store, and you have the 2 copies of your authenticated birth certificate, then you are ready to start signing and sealing your VSOF status docs, starting with the declaration of house seal. Be sure to sign and seal all of the VSOF status docs in front of a witness quorum and or petite jury as the document requires. And you can do some of the petite jury stuff over, obviously, Skype, or you can mail it to other people. As long as they know who you are, it's fine. Okay, so the next task is to appoint your judicial coroner of your house and download and read the handbill for that. The next task is to convene a petite jury of 12, meaning 12 of the people that have come of full age and people that know you, and seal out your proof of life and proof of age inquest with your judicial coroner. And the handbill to do that is here. The next task is to sign and seal your execution of will, declaration of claim of title. That's also known as the BC claim, or what we call the BC claim. And that you must have your state and federal authentications done on your BC before you can file this doc, because you have to attach it to the claim. And the handbill for that is, again, right here in the folder. Next is to sign and seal your rescission of power of attorney and letters of attorney. This gets rid of the capacity for them to continue to create bonds on your estate. 8, the next task is to sign and seal your executor-executrix appointment. This is very, very important. I mean, they're all very important, but one of the most important documents, aside from the KW, is the executor-executrix appointment, because the word executor and executrix is a barbarism to Roman civil law, meaning they can't hear it. And it's because that an executor is a more powerful position than a special administrator under Roman civil law. So they're administering everything under or by a special administrator. And we come along and we say, hey, wait a second. We have an appointed executor, and it's on public record. So now the executor has shown up to say, nope, you're not going to do that anymore. It's only going to be our orders, our decisions to administer the estate. So, and you could read, again, the executor handbill, read that to make sure you know what you're doing with it. Number 9 is to sign and seal your fee schedule. Again, look at the handbill for that. And then next, the kill warrant, handbill for that. And then the last thing to do in the set of the doc sets is to sign and seal your declaration of nationality, citizen status, and oath of allegiance by will. And again, the handbill for that is also completed. So that's the basis. From all those documents from there to there is the basis of the VSOF status docs. Then afterwards, you also get with the VSOF status docs, also number 12 and number 13 here. Okay. So after you have signed, sealed, and filed all the above in order, and they are listed, you add all of the foregoing public record numbers into the ordinance of the estate. And the ordinance of the estate is just a final document that basically has all of the previously recorded status documents onto it for easy process service to any corporation that comes up against you. And so then after you get all of this done, and if you get it in one single public record number, that's perfectly fine. Then you just put one public record number down on the ordinance of the estate, and then you file the ordinance of the estate. Okay. And then after you've accomplished all the rest of the above, when you feel the need to do so, then you can do your special master marshal's appointment, and these handbills are also available. But these are only for if you're actually going to court. These are court documents themselves. So you appoint a special master or marshal to your own court of record. It is a very, very good idea to have these filled out prior to ever having to go to court, however, because if you do appoint a special master and you ever get thrown in jail, then your special master can actually hold your court for you, and they can actually sue out a lawful common law writ of habeas corpus and force the court to obey it. If you do not do that, you will have nobody set up in a position that will be able to hold your court, and then therefore you would be stuck having to do something like a statutory habeas, which never works because it's at the will of the black-robed priest Savelle sitting on the bench. And then 14, 15, 16, these are things that you can also do. Your passport application, which we're obviously still trying to figure out exactly how to get a state passport, because this seems to be hit or miss sometimes. Your IRS estate number from your 32 EIN from the IRS, which also gives you your executor letter from the IRS that shows you that you're the executor. And then 16, the aspect of the property tax notices and the templates. And finally, and this 17 is the process, which we're still working on, obviously, is the final process of research of how to create and sue out one's livery in a formal probate hearing, which may have to go to possibly the state and be filed into DC probate. So, and what this will entail will be to open up an uncontested probate file, also called formal probate, and follow the rules of the probate court of your state. Settle the entire estate by first getting letters executor of said estate, which is the same aspect of that you've already had your letters executor signed. All we're doing is having the court sign off on it. Collecting all of the minor accounts and all the bonds and fidelity and the like that are out there, and other title to land, titles to effects, creditors, charges, if any, for anything against the estate. Pay all lawful taxes, and settle and close the entire gross estate. This final process, as I said, is still being developed because it will differ slightly from state to state. However, you can learn the rules of your own state's probate court for your state. And Ray asked in chat, why do you recommend authentication over apostille? Well, there's a very specific reason for that. And I believe, right in the folder here, if you guys get this folder, because this is the folder that contains all the handbills. And I expect you guys to read every single one of these documents. And if you've done so, you get down here to administrator and executor. Read these two next to each other, and you'll find out exactly why you have to be the executor and not the administrator. Now, as far as the authentication versus apostille, that is explained in the handbill of how to authenticate your BC, state and feds. But also, I'll just explain it right now for short. The reason is because an authentication is basically stating that the document is what it is, and that it came from the particular place of which it said it came from, and that it was signed and sealed by someone who was in proper standing to do so at the time that the document was created, whether that be usually the county registrar is usually the one that creates or signs and seals the birth certificates. And whereas an apostille, if you look up the definition of apostille, it's literally just the note on the side of a document. That's all an apostille actually is. It's just something that would be like in the margin of this document. That's an apostille. Okay. It's not an official anything. But the way that they get around, or the way they have been trying to get around giving us authentication of documents, is they go, oh, well, if they're a member of the Hague, if the corporation government has joined the filthy World Bank, if you will, and the World Court, meaning the Hague, then, you don't get an authentication. We'll only give you an apostille, which is why we tell everybody to make sure to get an authentication for the country of Taiwan, because Taiwan is not a member of the Hague. And then Fetchmoney asks, can your spouse or any other member of your house be your special master? The answer is yes. Anyone can be your special master. You can have more than one special master, which is why the special master appointment is specifically written the way it is, so that each special master may fill out their own special master appointment. It is written specifically that way to be ambiguous, is to just say, okay, any number of special masters you can have sign and seal the document. And the duties of the special master are listed within the special master appointment. They can do things like hold your court of record. They can sue out things in your name. They can process serve things if they wish. They can take depositions. They can do discovery if it were, a matter of equity or something in an inferior court situation, and sign and seal documents basically for you. And like I said, all of the listed powers of a special master are in the special master appointment. And they're more specifically described in the special master and marshal handbills as well. So basically with a special master, to differentiate between the special master and the marshal, the special master of your court should know what they're doing in court. So it's somebody that either has, obviously gone all the way through jurisdictionary, has a pretty good grasp also of the common law, has probably listened to a vast majority, or not if all, of my lectures on how courts work, the totality of law, the ins and outs of court, and the settlement of the estate, and understands all of these concepts that we're talking about here, both constitutionally and by the aspects of the rights of blood and kinship. And your marshals are just the people that enforce the judgments of your court of record. And they can also process serve if you want to. But you can have the thing about having marshals, if you're really worried or really scared that that an inferior court's going to do something, then appoint 25 marshals to your court of record and take them with you into your court of record, and then also have them operate as a grand jury at the same time if the fucking black robe priest up on the filthy bench decides to commit treason. Y'all just stand up at one time, at the same time, in the same voice, point at his ass and say, "We accuse you of treason." Watch how fast that motherfucker disappears. He won't be able to hit that little secret back door of his fast enough. Because we've done this before. And it scared the shit out of them. But nobody's taking up their power. So I'm preaching to a dead choir unless you're actually willing to do these things. So that's the difference between special master and marshals. Now, back to the doc. Updating your documents. Okay. So if you've ever been anybody who ever filed any garbage with Anna Von Dipshit or David Straight and Bobby Lawrence and any of these other idiots that are out here that don't know what they're doing, you can fix all of it. And all you have to do is you just say, basically, when you file your status docs, you say, this document amends in its entirety, public record number, and then write down all the public record numbers from all the other documents and other garbage that you've ever filed. And then, you reference it on there and say that this amends in its entirety, such and such record filed in such and such office on such and such a date. Any reference to record number, whatever, the one that was filed previously, of said county shall be required to include this amendment. So you just amend it in its entirety. Poof. It's like it never even existed. Okay. That's how you do that. That way you can always keep your docs updated, and also be sure that there are no docs in the past that you may have filed that would contradict anything in the VSOF Status Docs. And again, obviously change anything in red in here to your own information. How to sign. When you sign your name onto the status docs, you can do so in two different ways. Your proper name is your two given names. The quote unquote last name is the name of your house. So you must sign your docs as John Henry, or John Henry, or John Henry, House of Doe. You can do it either way, but you don't have to put the House of Doe thing on when you're actually signing your name, because you're technically, your given name, your proper name is your first and middle name. Or if you have three of them, it's three of them. Or if you just have one of them, then it's just John. That's it. John of the House of Doe. That's fine. People used to say, John, son of Henry, son of Richard, House of Doe. Right? They used to kind of bounce it along. The English got really crazy with that, and sometimes they have like 6 different names. But anyway. Okay, so remember always to put the hyphen between the two given names, and always add a colon before your house name. There is no need to put house of, but many people do, to make sure to tell that it is your house name. You should also sign your name in red or purple ink. Red pen signifies life and has even been found in the IRS manuals. to be how one is to sign certain documents to show this for the IRS. I don't know it off the top of my head, but it's in my IRS file. Purple is the color of sovereignty and is also perfectly fine to use. I would not, under any circumstances, use black, because black is the aspect of death, or also in accounting, the aspect of a negative account. Blue, I just wouldn't suggest to use also, because it's kind of like an accounting color. We just say red or purple, and we never had any problems with that. Other than red and purple might be a little bit slightly difficult to see if you try to make a copy of a copy of a copy, but you should never be doing that anyway. So, seal. So after they're signed, and okay, one more thing about the signing, because somebody brought this up the other day. They said, how are your witnesses supposed to sign? I said, exactly the same way you are. So they sign with their proper name, John Henry. And then if they want to, and this is up to your witnesses, they can seal the documents as well. They wouldn't have to seal. They can if they want to, but they wouldn't have to seal them with their own seal. All they really have to use, because you can always use your right thumbprint as your seal when in smaller areas on any kind of document. And you can also put your right thumbprint on all of your vocational science freedom status docs as well. That's perfectly fine. And some people also like to put a stamp on them and then sign over the stamp on the signature line and put your thumbprint on it as well. That's also fine. You can do that as well. I have no qualms about people doing that. I don't see any problem with it. It's not going to alter nor negate the document in any way. And if people believe that it gives an extra level of protection in some way, shape, or form, which I've never understood, but I'll just give them the benefit of the doubt about the whole oddity of the any sort of postal jurisdiction, or the aspect that it's now considered part of the post. Okay, fine, whatever. It doesn't alter in any way, shape, or form the validity of the document. So you can do that if you want to. Not necessary, but so be it. But if you have, another thing is, if you have a judicial coroner that's willing to do your doc set, but they don't have their own house seal, meaning they haven't gone through and they don't quite understand the VSOF process yet and the importance of having one's own house seal, that's fine. They can just use their right thumbprint as well. So just go and get a little red ink pad from office supply store, have them put the little thumb on it, and they just put it right on the paper. And if you guys have never done thumbprints before, I highly suggest that you just get a blank piece of paper and have them do it a few times on the blank piece of paper as kind of a trial run to see, okay, that looks good or that looks good, right? So you don't get a really, really smeared, weird looking, horrible thumbprint on your actual docs, because then you'd probably want to reprint them and do them over again. So, okay, so beware of all that. Okay, so then after that's done, then you seal them. Now, this is where you get your gold stamps from an office supply store, and you put the gold seal on all the places where it says, right next to it, where it says seal. And there's a place on all the bottom of the VSOF Status Doc sets, lower right-hand corner, that says seal in Old English. And so you can put your seal, and I tell most people to get their seals to come in from the right-hand side of the page. That's a little bit easier than coming in from the bottom of the page, because if you have because it's the way that your seal is oriented. And so you want it to come in from the right-hand side of the page so that you can go all the way up, or all the way down, at least the entire right-hand side of the page, which is kind of useful for certain documents that we've used in the past and other documents that I'm thinking about creating. You put your gold seal down on the paper first, and then you put your crimper over the top of it, and then you put it onto the desk, or you hold it in your hand, and you squeeze it all the way down till it makes a nice clear impression through the paper and through the gold seal. The thing about the gold seal is that make sure before you put the sticker onto whatever status doc that you're sealing, make sure that you see how far in your actual embosser seal will go into the paper, because some of them are longer than others. And I suggest trying to get a bigger one if you can. I mean, you don't have to get an enormous thing, but I mean by bigger is longer, being able to get deeper into the paper. Because the last thing you want to do is put your gold sticker somewhere in the middle of the paper and then make it really difficult to get in there and seal. I mean, even if you kind of screw up and do that, you can fold the paper and then kind of get your seal in there and then crimp it and then pull it back and hopefully not get any sort of like bad crease or in the side where you kind of folded it under to get to it. I've had to do that before when I first started sealing things, because it's like, oops, that didn't that wasn't put far enough to the right side of the paper. So just be aware of that, so you don't have to do anything goofy like that and make it any worse than it is. So, okay, so yeah, again, this is what I said. So you should test how far into the side of the document your seal will go before you place the sticker, because once you put it on the paper, meaning the sticker, you cannot remove it, because those stickers, those gold stickers and silver stickers, are made with such a type of adhesive that it cannot be removed from the paper without ripping the paper. And that's kind of the reason why they make them like that. Okay, an additional sign and stamp. If you wish to place a 3-cent stamp on the back final page of each of the docs, that's fine. People have asked me about that. I don't have a problem with doing that. Or in the lower right-hand corner and sign over the stamp. Your right thumbprint gets placed over the stamp, meaning you don't want to just cover the whole stamp. You kind of do half on the stamp, half on the paper. I mean, if you want to do this the way that I've seen people do it. But again, this is completely if you want to kind of thing. Additional initials on each page. This is something that a lot of people do, and a lot of, I think there's even some Roman civil law based upon state law of valid wills, that each page has to be initialed by the creator. So you can do that as well. I'm certainly going to do it with my documents that I actually need to get updated, because I did my doc set a while back, and now we've gotten it. So we've updated so many things that I definitely need to redo them. So I will definitely be putting my initials on each and every page, and you can just put it on one place in the page. The other way to do it is to put it into the 4 corners, so that you put your initials in all 4 corners of each page. That's fine too. And it might be a little bit tedious, but hey, we're only doing this one time, so might as well just get it done right. Okay, and then filing your docs. You can file your docs in any county recorder's office in the entire United States of America, right? So it doesn't have to be your birth county. It doesn't even have to be the county that you live in, because if you have a county that you live in that happens to be run by communists and won't let you access the public record because they give the documents to a filthy Khazarian mob attorney or district attorney, same thing, and the district attorney tells the county clerk, don't file those. We don't take those documents. The stupid clerk's going to listen to the Khazarian mob piece of shit. They're not going to follow law. And so if you have a communist clerk like that, go find another county. There's a whole list of friendly county recorders' offices that's on the Vocational Science for Freedom Gilded server that people have recorded anything onto, and they'll take it. I don't care where it's recorded. It's irrelevant, as long as it's somewhere on the public record, because it's the serving of the documents after they've been on public record that matters, to put the rest of the Khazarian mob and all of these filthy corporations pretending to be governments on notice of who and what you are. You can file them in other places. And by the way, you can file them into your birth county under miscellaneous or any other county. And some people also file them onto the land records, but sometimes they won't take them. The other way to file them, or under what other category you can file them under, is also just file them under wills, because every single one of the status doc set is a continuation of your will. So both options are fine to do. Some people have said that the county recorders will not file them into the correct record. That does not have to do with land records. If that happens, just ask them to file it in the miscellaneous file. And if they still deny your rights to file the documents, the first thing you need to ask them is this. Quote, please produce the law upon which you rely to deny me access to the public record. Close quote. I'll say that again. Please produce the law upon which you rely to deny me access to the public record. Close quote. If they have no answer to that, kindly state to them, quote, I wish that these documents be filed on demand into the miscellaneous category of the public record. Close quote. Or you could alter it slightly. Quote, I wish that these documents be filed on demand into the will category of Winnebago County Public Record. Close quote. If you want to get more specific, it's fine. But you always say, I wish, because a sovereign's wish is their subject's command. And they're all subjects to us because we are the sovereigns. So say it nice like that. Just give them a wish. If they still won't do it, they still want to get pissy, you can, because I've had friends that have done this as well. You can, if you want to, right then and there, call 911. And you can get the sheriff there. And you can tell the sheriff, I wish to create a police report right now against them for failure to allowing me access to the public record. Now, it doesn't matter that the stupid clerk doesn't like it. It doesn't matter that the sheriff's deputy doesn't like it either. He has to take the report because you have witnessed a crime. So it is your duty to report it. It doesn't fucking matter that neither one of them understand the law. It doesn't fucking matter that neither one of them is going to do anything about it. The fact is that the police report is created so that you can then take it to a grand jury. That's the point. Okay? So you can call 911 and I'm right there if you want, but make sure to, one, that you have a recording device on you so that all of it's recorded. And that two, you make sure that they create a police report and you make sure that you get a copy of that police report if you want to go that route. If you don't want to do all that shit, you don't want to be bothered, go find another county. Okay? It's not that hard. Just get it done. But if you want to throw them up against the wall, fine, do it. But that's how you do it properly. Okay? All right. So what you're looking to get on each of the VSOF status documents is a public record number, or sometimes book and page number at the top or on the side of the margin of your docs, showing that they have been filed under the public record. If you get a county clerk that will not file the BC or any of the docs at all, you can call the sheriff and, again, command a criminal complaint against the clerk for secreting the public record. I wish to report a crime. She is secreting the public record. And there's United States code for that if you want to throw them under the bus for that. There's also state law for it as well. There are several counties around America that will file them and send them back in the self-addressed stamped envelope that you provide. So do not push the issue of point of conflict if you can help it, because you really don't need to. But again, if you want to throw them under the bus, I just told you how to. The other option is to kindly ask them, quote, what do you think the Department of Fraud and Waste will think about you denying me access to the public record? Close quote. You can also say, and if they play stupid and they're like, what? What'd you say? And you say, the Justice Department. This means you're going to contact the Justice Department and make a federal issue out of it. Usually when you say that, and I have seen this, I have literally witnessed this with my own eyes, somebody doing this, that was one of my mentors, that if you say, the Justice Department, I wonder what they'd think about it. They will jump up and do whatever the fuck you tell them to do, which is exactly what they did when my mentor said that to them. Because they know that they're violating federal law when they do that, because you cannot secret a public record. That's the same thing as denial of being able to file. It's the same thing as secreting, same deal. It's like saying, the public record doesn't exist here. What? No, you get to go to jail. And if you really want to get sneaky with it, you take them into federal court and do it as a qui tam action. Guess what? You can get a percentage of their fines that they have to pay. So you want to make some money on the side? Do that. All right, to continue. There are different fees involved in every state. Michigan has had people file for free and only ask them for 18 cents per page for certified copies. This is something that Blue Star and I actually did to his clerk in Michigan, which is kind of what we said above. I literally said, not the Justice Department thing, but the part above it regarding, I wish that these documents be filed on demand into the miscellaneous category of the public record. And then I asked them, please produce the law upon which you relied to deny me access to the public record. Well, Blue Star had me on speakerphone, which I didn't know at the time. So the clerk of the court heard that, or it wasn't the clerk of the court, sorry, it was the county clerk, county recorder. And the county recorder instantaneously, meaning the county recorder that's actually the duly elected county recorder, tapped his assistant on the shoulder and said, file whatever they want, no charge, and walked back into his office. He just gave up. Okay, so that's why we can file stuff in Michigan for free at that county and only have to pay 18 cents per page for it. Now, Blue Star has gone down and filed at this county for other people, but he does ask an amount for it because it is kind of a trip for him to get down there and back. Okay, and then other states like Illinois, they want $120 for one fucking document to be filed, which is absolutely asinine. And, seeing that there are over 10 documents to file, that can get ridiculous. So be sure to ask your county recorder what their fees are and if their fees apply to you as one of the people of the said state. And also, one last thing, make sure that you get a list. before I would ever file anything into a county recorder's office, I would specifically ask them for the list of their categories. Every county recorder has a specific category list that they have, and they have to give it to you by law. Next part, service. So after they're all filed, signed, sealed, done, you can go get certified copies, then service. Okay, after filing all the docs onto the public record in the county recorder's office, you should get a few certified copies of each of them from the recorder for process service. After you get these copies, they must be process served. Not just green carded to them in the mail, meaning a process server, someone over the age of 18 goes into an office and drops it on their fucking desk. And then make sure after he or she drops it on their desk that they write out and sign and seal a proper process service affidavit. And then they go and get it notarized so that you have proof that whoever the hell you just dropped them off to was done so by process service. Because a process service affidavit in any court, I don't give a shit what jurisdiction it is, stands as God-level evidence that the other party was put on notice. And that's all you give a damn about. You had notice. That's it. Because you have to draw your line in the sand lawfully, and that's called due process. Due process exists for both the rights of the plaintiff and the defendant. Just remember that, everybody. So, okay. So you make sure you process serve them on the appropriate offices and agencies that are coming up against you. And then obviously service does not mean mailing them off the green card. Service means personal service by a process server that will send you back what is called a process service affidavit. This is the proof from another people over the age of 18 that the docs were served to the exact man or woman that needed to get them. Once served, they must act accordingly or be bound to compensate you for the bond amount in the KW for the unlawful administration of your estate. Next, who to serve. The first service of the entire doc set should be on the Secretary of State of your state where you are domiciled. This will put not only every single state employee on notice, but your status, but it will also put, and this is according to statute in Texas, all of the corporations that are chartered out of that state on notice of your status docs as well. Now, that was a very interesting law that we found because it found out that, and again, at least this is in Texas, we'd have to track it down for every state, but well, that might behoove us to find a county recorder in Texas now, come think of it. But anyway, that when the Secretary of State gets served something of a notice, literally they have to put every corporation that's chartered under the state under the same notice, which I found absolutely fascinating. But it actually makes perfect sense. But anyway, so that's a statute we found in Texas. The second service should be on the Secretary of State of the United States Federal Corporation so that any and all records that they have regarding your estate are corrected to reveal the change in your status and put the entire United States government on notice of their appointment as trustee and requirement to post bond or be sued for the same amount and kind in case of unlawful administration. Additions and subtractions. Nothing is to be added or removed from these docs. They have been proven to work in the form that they have been given to you. Many people have messed them up by altering the docs or adding things to the signature lines like without prejudice, which in short means I don't really mean anything by signing this. The only time you would ever want to sign something like that is when the state is forcing you to sign a contract under duress, like as in a bond when you get out of jail. And then the court use of the status docs. Many times, people are in some kind of altercation with the corporate state or with some filthy bank before they start to learn anything about the law. As I am well aware of this tendency in human nature, it does not excuse one's own duty to know the law, protect your substantive rights, and claim your own estate and handle your own affairs as one who has come of full age and is no longer an infant. That, having been said, these docs are best used before anything or anyone comes against your estate, not after the fact. Because when did Noah build the ark? Before the flood, not after. Okay? However, these docs have ended court cases and zeroed out very large amounts of debt, even after being filed onto the public record, after charges were filed against your estate, and in some civil actions being filed against the estate for debt. But it is always better to have your defenses up before you get attacked, not after. That's basic Sun Tzu, people. With all that having been said, when you have an open case, the status docs that you will want to file into the case and serve on the other party in the case are the following: the seal notice, proof of life and proof of age inquest, executor appointment, rescission of power of attorney, KW, fee schedule, and special master and marshal's appointment for your court, if indeed you are in a court of record where you can appoint same. When you serve the kill warrant onto the other party, they will have to decide if they want to attempt to administer your estate, by thereby binding themselves to the contract, accepting the appointment as trustee of your estate, and thereby having to put up a $300 million bond for potential fiduciary malfeasance of your estate. When it comes to the court, you'll want to serve the court administration and the judge with a certified copy of the kill warrant. This will place them both into the same position, meaning they've been served and they are now appointed trustees. They don't become bound trustees until they administer, but they are still appointed trustees the second they get served. And you can read all of that understanding within the KW itself. It's all laid out in there. Because all hearings, meaning in the inferior courts, are probate court hearings, not dealing with criminal charges, but with an administrator handing out fines and fees for the unlawful use of abandoned estate property, meaning your body and lands. And what the KW does is give them an offer of contract for the administration of the res of your estate, saying, okay, you want to keep administering, well, that's fine, but this is what you're going to bind yourself to. And it's no different and just as lawful as any user end license agreement that any of you enter into before you start using a software. It's the same idea. You use it, you're bound. That's it. However, this is only a stopgap to get them to stop the administration of your estate. The ultimate goal is to obviously sue out your livery for your entire gross estate in a formal probate hearing in a court of record. The explanation of each status doc. Each status doc has its own handbill that explains the who, what, when, where, why, and how of each document, as have been listed in this handbill. Please refer to each as needed. If you have questions, join the Gilded server. Need contacts? You can email me at vsof@protonmail.com. One last time, all of the rest of the status docs are in here as far as where to start and how to get this done. And this was the document that we were reading from today. Let me back up one. This one here, General Handbill. And you can download any of these right out of here from the link that I gave in the Mega Chat, or in chat. And it'll also be in the show notes for the classes if you are watching this online on any of the platforms that we are on, which, by the way, are Odyssey at VSOF:8. This is the main repository of all of the classes for the Vocational Science of Freedom. This is where we make sure we keep everything so that nothing gets lost, because Odyssey works on a blockchain. And then we're on Rumble, which is, again, just rumble.com/c/VSOF. And our Gab group number is 30721. And we are also on YouTube, again, at Vocational Science of Freedom 2. Because we had to restart that because we talked a little bit too much about things that the Kazarian mob doesn't like. Okay, so let me scroll up in chat here, make sure there's any other questions. Amy asked, how many people have completed our doc set so far? That's a good question. I don't keep a running number, strangely. Maybe I should. I could go back into my records. I do keep a spreadsheet of just names, just people that have, done, paid, meaning they paid for it. I got their doc set done and I sent them to them. So I do have a record. I've just never decided to start going down and making a counting list. So I don't know. I guess the question is, why do you ask? If you're asking if it's over 25, the answer is definitely yes. Lisa asks, is there anyone in Georgia that I can appoint? I plan on taking the jurisdictionary course very soon. I'll be looking to see if we can do the same. There are people, you mean people to appoint for what? Need to be more specific. There's a lot of different appointments that go with the VSOF Status Doc set. There's your marshal, your special master, and your judicial coroner. There are some judicial coroners on the server, but I don't know if they're willing to or fully prepared to do a doc set for someone they don't know. I don't know. You'd have to talk to them. There are some other people that do have friendly judicial coroners, and maybe I should start making a point to ask everybody that when you do find a friendly judicial coroner, ask them if they'd be willing to do a doc set for somebody else for, I don't know, 3 rounds of silver or something. Just make sure you compensate your judicial coroners. They are, after all, members of your own court, so they do deserve compensation. Mr. Fellas, even for load of title and in reference filing with the county. Sorry, you must have asked that in the middle of class, and I don't know what your reference is to. If you can re-ask that again, that'd be great. Lisa, can you file online? Yes, you can. There are county recorders, the ones that I have listed. Again, the friendly county recorders that I've listed on the VSOF server, and I must just open it up so everybody can see it. Some of them you can do it all by email. I think it was no, it wasn't the Pennsylvania one. I thought it was one in Georgia that maybe I don't have the one in Georgia listed here. If Aubra's on, she knows because she filed it in, I think, Georgia, all electronically. It was all done electronically. And she was all the way in California, I think. So there is one that can definitely be done that way without having to mail it in. So yes, you can file online. I personally would just talk to a county recorder or just pick one of the friendly county recorders and then just get their information, meaning get their price sheet, figure out how much they want, do the calculation yourself, fill out the price sheet, put in send them a personal check or send them a money order. Just go down to the post office, send them a money order for the exact amount of whatever the totality of the filing fee is, and make a simple little cover letter that just says to them, "Dear so-and-so county recorder, please file on demand the following documents in the order of which they are stacked, and the check for the proper amount for the filing is enclosed along with the application," or whatever, something like that, however you want to say that, and just mail it to them, and they'll be fine. Mr. Hodel says, yes, you can file online with Pima County. It's in Arizona. I think that might have been, one of the other ones. It was a friendly one. And Maria said, no secreting of public stuff, funds, records, processes. Yeah, exactly. But that really comes down to secreting the public record. Like I say, when they just say, oh, you can't file here. I mean, it's the same thing as like saying we don't have a public record. It's like, what? Really? But anyway, Green Smasher asks, what county in Michigan was that? Oh, good Lord. What was the name of that county? Shit. Sorry, that was not the name of the county. I think it's whatever county Ann Arbor's in. I don't know what it is. You'll have to look that up. Sorry, Green. But yeah, whatever county the city of Ann Arbor's in, because I know that was the city they went to where the office was. So it's got to be in that county. So that's all I can tell you. Amy asked, isn't it illegal for the court recorder to charge and make money off of people needing to file paperwork? Maybe it depends on the state. Well, in a sense, it's illegal to make people pay money to file court cases, because that would be barratry, which is the profiting or making of money from the law. But it's basically illegal for them because there's constitutional issues regarding the fact that we have right to the public record. That's really what it comes down to. Now, is it illegal for them to make money? Well, yes and no, but it's that weird line in the sand that they're never going to cross, right? Are they a private for-profit corporation that does not have any actual purse connected to the state? Okay, if they are, they can charge you whatever the fuck they want. However, if they're not, and they are actually a part of the state, well, then they got a problem, because then they're not supposed to be charging you anything. But if they're going to admit to the other, okay, at least you got them on that. But at the same time, then they can charge you whatever they want to. So, Green asks, does the seal have to be gold, or can it be any other color? Yes, it's preferably a gold seal. It's just how it's always been. I mean, if you want to get really, well, no, I wouldn't do that. I was going to say, if you want to get really fancy, you could you could get a hot wax sealer, one of the heavy little stamp things. And you put the wax down, and then you set the seal on it and push down a little bit. And really, I mean, I wouldn't do that because you're going to be mailing a lot of these documents around, and a lot of those wax seals can kind of fall off. So, yeah, the color just best to do is always red. So, yeah. Lisa asks, has anyone done a FOIA to the IRS to get all of the 1099As, 1099Cs that were filed since they were 18? Well, unless people have been filing 1099, I don't know why anybody would be filing 1099As and 1099Cs unless they were doing it themselves. But there's no secret IRS 1099As or 1099Cs that are out there that you wouldn't have done. Aside from the ones that, oh, I see what you're getting at. You mean all of the ones that would have been done based upon your signature creating credit within the filthy Luciferian system. If that's what you mean, then no, I don't think anybody's done a FOIA on that. And besides, you can't FOIA the IRS anyway. It would be, if you wanted that from the IRS, the best way to get that would be demanding your full entire numinant printout, also known as your master file. So, Viper asks, can you do a class on credit reporting agencies? Oh, yeah, thank you. That was a good point. Actually, I'll put that on the calendar, Viper. I will make sure that is next Wednesday's open roundtable, because we had talked about that before. I just didn't think about it today, and I did want to get this out of the way because I had a lot of questions about status docs recently. But yes, I will definitely do that. Any friendly recorders in Kentucky? I don't know. I just have the list of what I have. And I'd like people to especially send me more lists. So if you find a county recorder that does have, like, they just have no problem, they go, sure, no problem, file them, and they do it and they get you back your thing. Please send me whatever county that is so that we keep track of, good, lawful, happy county recorders. Okay. Yeah, well, the whole thing about suing out the livery, Green, the totality of suing out the final livery is going to be, my goal is to have all of it completely completed by the end of the year, and this being 2023. So much of it is in process. There are a lot of people that still need to take up the mantle, though, and start filling in the positions in the committees to get this done. Because, again, remember, everyone, I'm only one guy here, and you guys got to remember that there's other parts of this VSOF Gilded server. So if you go to the committees and you go down, we still need people to finish out what you were talking about, the delivery, the entire suing of the state. We need somebody to take a committee chair. Someone needs to take chair of DTCC, number 7. Somebody needs to take chair of 13, Social Security issues and removal. And somebody needs to take chair of, I'll probably take the chair of number 3 of settle the estates. And then the rest of the assignments, if you will, I will put out from settle our estates committee, and we will have hopefully a monthly committee meeting on that. And I'll put everything also that I'm doing in the estate forum, everything that comes along with what this will be as far as the suing out of the livery. So, but again, I'm only one guy, so you guys got to help out by getting into those committees and helping out here. So, all right. So, looks like that's all the questions we had. We're a little over time, actually quite a bit over time. So with that, if you guys have any other questions, obviously put them. Always make sure to put all your questions and answers into the question and answer room. That's why it's there, right on the main chat and the main server. So please do so.
So with that, we'll get into the explanation of each doc in each separate handbill. And if you have any questions, obviously you can contact me on Gilded. And this again is the Gilded link, which you can also find in the upper right-hand corner of the Vocational Science of Freedom YouTube page where it says Join Gilded. And with that, we're at 3:30. So let's take a 15-minute break now. Be on break for 15.